Hello, my true crime lovelies. I hope you are well. Happy Sunday. So, a motion in limine has been filed, and it's not the one we've been waiting on. Holy schmoly. So before I get into it, first I want to say thank you to all the members who joined the Zoom this morning. Next time I will give more notice, longer lead time, so people can plan accordingly if they want to come and not after your schedule has already been done. But I do appreciate those of you guys who made time for me. And yeah, we'll talk about it in the member spaces. The girls suddenly need to talk to y'all. I swear they've been here quiet. They're little children. For those of you guys who have been here for a while, and by a while, I've only been 3 months on YouTube on this channel, so maybe like 2.5 months ago, you'll remember I said this. So I don't want to be an I told you so girl. So let me just get into it. And if you remember, you remember. If you know, you know. Get down, girls. Get down. Okay. This was filed October 6th at 3:28 p.m. Defendant's motion in limine. The defendant, by and through the undersigned counsel and under sections 90.402, 403, 404 Florida statutes, requests this honorable court to exclude certain evidence at the trial of this cause, specifically redacting portions of the 2-hour video interrogation at the Orange County Sheriff's Office. And as grounds alleges as follows. So he couldn't get the whole thing out, but Owens is not to be deterred. He's like, well, I'm going to get some of this out. I'm going to try. I hope the state sees this and responds tonight, but if not, we'll be up in Adam early in the morning and figure this out. So the defendant, Sarah Boone, is charged by way of information. So not by indictment. We talked about that before. With the single count of second-degree murder, the offense allegedly occurred on February 23rd, 2024 in Orange County, Florida. I don't know that they've said that, or did I miss that before? I know his time of death was called on the 24th. Okay. It allegedly occurred on February 23rd. During the homicide investigation, the defendant was asked to come to the Orange County Sheriff's Office. The defendant arrived on February 25th, 2024, and was escorted into an interrogation room. A custodial interrogation of the defendant then ensued. So none of that is disputed, as we discussed after the hearing last week. It was custodial. She was escorted by Scott Lowen, who had on his gun as they went up the elevator. And then Miss Chelsea Copesel invited her in and directed her to sit in that nefarious green chair. Not disputed. The approximate 2-hour interrogation was recorded by audio and video. We've all seen that. During the interrogation, the two homicide detectives questioned the defendant at length concerning the facts and circumstances surrounding George Torres's death. At length, Sarah had some questions too, but okay. At such time, statements were made by the defendant and the two detectives. Some of the statements made by the party should be excluded and redacted from the video mentioned above. From the transcript of the interrogation video titled Transcript of Taped Interview of Sarah Boone conducted by Detective Chelsea Copesel, case number 2017904. The first section of evidence to be excluded. Number 6, the following dialogue from pages 69 through 71, beginning on line 6 of page 69. Detective Scott Lowen, hold on. You had 2 different neighbors that lived directly next to you. You asked to use the restroom and they told you no and turned you away. You had to go, across the way to somebody else. Oh no. Okay. Kim and Eli. Kim is not a nice person. Okay. She's just automatically not nice. Even after me and Lucas went over there and introduced ourselves, she's just not a nice person. If that ain't the pot calling the kettle black, ma'am, then why would you think she would let you use her restroom? Because Eli was in there. Eli comes over and talks to us sometimes, which I think pisses Kim off. Okay. Because he comes over and talks to us. The two of them, they're like super standoffish all the time. My neighbors, down the street, down the way. Their toilet was broken. They had stuff in their bathroom. So then their bathrooms, like, go over there and try over there. There's 2 bathrooms. So both their bathrooms, I wouldn't let nobody go upstairs and use my personal bathroom. That's what the downstairs one is for. Or somebody you knew. They're in the process of doing all this stuff in the kitchen. Okay. And there's stuff in the bathroom and the toilet doesn't work. Just move across the way. No problem. And of course they let me in. Them, they're together. They're families. That's what you really want to know. And I hope it doesn't get them in trouble, but he is over here illegally. So he's trying to work on getting his green card. This is what I said that they were going to try to get redacted because it makes her look like the little shit starter that she is. Detective Scott Lowen, what does that got to do with you using the restroom? They didn't want to be involved. And then Chelsea comes back in. So that part makes no sense. They didn't want to be involved because he's here illegally. Then why did you go over there, ma'am? That makes zero sense. I mean, they rightfully probably didn't want to be involved with you, drunk person going in to ask to use their restroom. I've lived here 4 years. No one has ever come to ask to use my restroom, either one of my restrooms. I lived in my other place 6 years. None of my neighbors came over to, it's weird. Okay, so Detective Copso comes in. What's the address? And then Detective Scott, no, I was asking last night because, we had several different people. Sarah says, assuming stay in the neighborhood, come up. Eli and Kim, it says him here, but Eli is the male. So I think just someone in Owen's office had a typo. Detective Scott Lowen saying that she was drunk on a regular basis. Eli and Kim. Okay. Did you ask Benny next door? Those are the ones next door that she asked. Oh, it says Sarah Boone, but I think this is now Scott. Scott said those are the ones next door that she asked to use the restroom and they said no. And then this should be Sarah. No, she said no. Detective Copso, okay. Sarah Boone, like I said, she's not a nice person. And here, for some reason, I think when they were bolding and italicizing this, they changed the spacing, which is why you have these large gaps in between. So instead of this part being left adjusted, it's now evenly. You guys who type know what I'm saying. And you guys who don't worry about it. So number 7, the exclusion of the said evidence is required due to lack of relevance under section 90.402 Florida statutes. In addition, the evidence is improper character evidence under section 90.404 Florida statutes. I think they'll probably be okay with this. I mean, it's more prejudicial than probative. Like that, in my opinion, my non-legal woman sitting on her bed talking to strangers on YouTube opinion. So the second section of evidence to be excluded, page 53, line 11, Detective CK, so Chelsea, well, he's dead as a result of your actions. Line 13, Detective CK, he's dead as a result of your actions. Line 14, Sarah Boone, I understand that. Page 55, line 24, Detective Scott Lowen, I have one last question. You realize you're the person that killed him, right? Page 56, line 1, SB. I thought about that. Page 92, line 15, Detective Scott Lowen. Well, intention or not, George is dead. You act like when you say unintentionally, that absolves you from everything. 14, the above evidence is improper opinion testimony by Leo. Law enforcement cannot express opinions on the law or the ultimate issue of fact for the jury. See O'Day v. State, Florida District Court of Appeals, 2011. We might want to look that up. In addition, said statements assume the truth of contested facts and encourage the jury to find the defendant guilty as charged between because a law enforcement officer said so. If this opinion evidence is admitted, the jury may assume the validity of the law enforcement officer's opinion because it was allowed in evidence and rely on the opinion in finding the defendant guilty. The issue of causation is exclusively the jury's job. This opinion evidence invades the province of the jury's fact-finding mission, the province. The exclusion of any or all of the evidence described above is required as the value of such evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, and would serve only to inflame the jury. Section 90.403, Florida Statute 2010, C. Smith v. State in 2020. Wherefore, the defendant requests this court to enter an order excluding the above statements from the videotaped interrogation in this matter. Okay, we're going to look up ODV State, but first I want to say I don't think, obviously without having read the cited case, that this will be excluded, right? Because they are in the interrogation. Sarah has already admitted to killing him now. She's saying it was in self-defense. So there really is no need to take out that Sarah was responsible for his death or that law enforcement opined that he's dead as a result of her actions, because in order to have the battered spouse defense, that is an affirmative defense. So she's saying, yes, I did it, but here's the circumstances, and therefore you should be more lenient on me. Right. And so I don't, just based on the circumstances of this specific case, I don't think that should be struck from the record. And the jury gets to decide. They will see law enforcement testify. They will see Sarah testify. They get to decide who is more credible. Right. And they can decide if they believe all of that person's testimony, some of that person's testimony, or none of that person's testimony. So for those reasons, I don't think the judge will strike those from the record. But let's really fast look up O'Day v. State. Will this let me copy into Google? And this is a motion in limine, which is, I looked it up. In limine is a Latin term that means at the threshold or in the beginning. And so it happens before the trial. I know we've all seen motions in limine, but I don't know if we knew the Latin exact reference. Okay. So here's case law. I'm going to pull this up. We're going to go through this together. Ooh, it's faint. Let me get it a little bit bigger. It's really light print. And then, okay. Nope. Did not mean to do that. Okay. So this was at the Appellate District Court of Appeals, 4th District. O'Day was the appellant. The state of Florida is the appellee. So whatever happened, the state won the case, and now this person is appealing. Abdel O'Day appeals his... Oh, wait, what is this at the bottom? I'm going to close that. That was the cookie. Do you accept these cookie policies? Yes, sure. Okay. Appeals his judgment and sentence after a jury found him guilty as charged of attempted first-degree murder. On appeal, O'Day contends the trial court erred by allowing the jury to hear the investigating officer's opinion that his claim of self-defense was not legally valid. The opinion was expressed during an interrogation of O'Day and during cross-examination of the officer in front of the jury. O'Day also contends the trial court erred by giving erroneous jury instructions regarding the justifiable use of deadly force. Lastly, O'Day contends that trial counsel rendered ineffective assistance by failing to object to the officer's opinion statement regarding self-defense and to the improper jury instructions on the justifiable use of deadly force. So we can infer that this appellant was successful. Otherwise, I don't know why we would be citing the case. I have to get a trial for this. A trial. Okay, hold on. We're back, and I found a different case, a different version of the case that has the full, and everybody started right back up where we left off. But this was not affirmed, but there are two interesting pieces in here. So I'm going to share the part first that I think is most relevant, because I know some of you guys just came here for those specific, just the information and not to hear all the case law. So let me share that first. And then for those of you guys who want to stick around, we'll go into the other bits of it. So, okay. Detective Hardy's statements regarding self-defense. The court has observed generally a witness's opinion as to the guilt or innocence of the accused is not admissible. Example, Martinez v. State, which was a Florida case in 2000. Florida statutory law excludes such opinion testimony regardless of its relevance on the grounds that its probative value is substantially outweighed by unfair prejudice to the defendant, right? So more prejudicial than probative. The danger of prejudice increases when an investigating officer is permitted to offer an opinion as to the defendant's guilt. But in this case, they weren't offering an opinion. They were in an interrogation, right? I feel like offering an opinion happens when you're on the stand, but we'll see. Battle v. State, Florida 4th District Court of Appeals, 2009, emphasis added. It seems axiomatic that an officer's opinion regarding a legal I am starting and stopping this video, so if it's a little choppy, I apologize. I will do my best to edit it to make it less choppy. This court has recognized there is a difference between an investigating officer giving an opinion as testimony before a jury and an investigating officer giving an opinion during the interrogation of a suspect. There is a difference, right? Because they're also allowed to not tell the full truth or just not the truth. I mean, there's no half truths. It's either the truth or it isn't. In the interrogation, where on the stand, they have to tell the truth, right? We recently upheld the admission of evidence of investigating officers stating their opinions to a suspect during an interrogation. In Eugene v. State, this court affirmed a first-degree murder conviction and life sentence despite the appellant's argument that the trial court erred in allowing the jury to hear over defense objection 4 statements by the interrogating detectives that indicated their belief as to the appellant's guilt and their theory as to what happened. We said not everything a detective says to a defendant during a recorded interrogation is unfairly prejudicial under Florida Statute 90.403. We concluded that an interrogating detective's statements to a suspect, and this is the appellate court talking when they say we, as my mother always says, what do you mean we? You got a mouse in your pocket? It's the court that's saying that, that's writing out this ruling. So we conclude that interrogating detective statements to a suspect, when placed in their proper context, could be understood by a rational jury to be interrogation techniques used by law enforcement officers to secure confessions, right? So the jury is able to discern, a reasonable person is able to discern, okay, that's what they do in the interrogation, and now we're here in court. As the state aptly points out in its answer brief, the issue of whether an officer's out-of-court opinion of an accused defense during an interview should be excluded appears to be an issue of first impression in Florida. The state discusses cases from 6 other jurisdictions, which the state contends deal with an the state discusses cases from 6 other jurisdictions, which the state contends deal with an analogous situation. However, we do not agree that the cases deal with an analogous situation. All of the out-of-state authorities cited by the state address an interrogation where the officer gives an opinion that the suspect was not telling the truth. In some of the cases, the officer stated during the interrogation his opinion of what happened factually when the crime occurred. In some of the cases, the officer offered an explicit opinion that the suspect was lying. None of the cases deal with an officer stating his opinion as to whether the defendant's assertion of a legal defense has merit. Law enforcement officers have never been considered to be legal experts in a court proceeding. However, a juror may reasonably assume an officer has some training in criminal law and therefore can properly opine as to the legal merits of a defense to a crime. Allowing an improper opinion by a law enforcement on a matter of law encourages an improper assumption on the part of the jury that the officer's opinion is legally correct. So even though they may have a bachelor's in criminal law, right? They are not considered legal experts. And all of us trial watchers have seen when experts get on the stand, you have to sort of go through their CV first and all of the things that they've done. And then they get certified, I'm not sure the exact word, as an expert. Both the person who's bringing it, so if it's the state who's bringing the expert, they'll go through their CV. Then the defense will also, question them on whatever their legal expert is. And then they'll both agree, yes, he can be admitted on the record as a legal expert. You're not going to get that with a Leo on the stand. And it's saying, plainly, have never been considered to be legal experts. So they would call in like a law scholar to be a legal expert. So while it is safe to assume that jurors can recognize as an interrogation technique that an investigating officer may offer an opinion about facts during an interrogation to elicit a response from a criminal suspect, it is not safe to assume that jurors can recognize as an interrogation technique that an investigating officer may offer an opinion about the law during interrogation to elicit a response from a criminal suspect. So I'm not sure if they were offering an opinion about the law, they being Scott and Chelsea, in the way that is happening in this case. They just said, he's dead because of you, which I feel like is not in dispute. So I'm not sure what Owens is going, what his end game is, other than I for sure felt like he was going to try to get out the comment about a person being illegal. One, because it's just not politically correct. A human being can't be illegal. But this other bit, I think I'm a little bit surprised that he's going for it, but we'll see. Thus, we determined it was error to allow the jury to hear the opinion of Detective Hardy during interrogation that O'Day could not legally claim self-defense in this case. When Detective Hardy responded to questions by defense counsel during cross-examination, the error was invited. Okay. So defense counsel basically solicited that answer. Huh. Okay. So then, but this person is also, the person who filed this also is claiming ineffective assistance of counsel. So anyway, under the invited error doctrine, a party may not make or invite error at trial and then take advantage of the error on appeal. Opening the door. He opened the door. He opened it and said, come on in. We next examined whether the error of allowing the jury to hear Detective Hardy's opinion of O'Day's claim of self-defense during interrogation was fundamental error, requiring reversal as an exception to the contemporaneous objection rule. Our Supreme Court has stated, and I believe when they say our, they mean the Florida State Supreme Court, in order to be of such fundamental nature as to justify a reversal in the absence of timely objection to the error, must reach down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. Brown v. State, holding that the alleged error did not permeate or saturate the trial with such basic invalidity as to lead to a reversal regardless of a timely objection. So I don't think that would be the issue in Sarah's case. Well, one, no one's going to be opening the door because we're going to decide before we get into it, right? Because it's a motion in limine. But I think that a verdict could be obtained if Judge Kranig rules that that is admissible as far as not redacting it from the interrogation. Obviously, no one's going to testify on the stand not no one. Scott and Chelsea are not going to testify on the stand that she's guilty of second-degree murder, right? Which they said none of that. They just said he's dead as a result of your action. So they're not even actually at that point. I mean, obviously she's in handcuffs, so there's something wrong, but they And in fact, the evidence shows that it was not agreed upon, decided by Leo and the prosecutor's office, I think until March, like the end of March is when she was actually charged with murder and, oh my God, second-degree murder. So anyway, I feel like this doesn't apply. Okay. It does not appear to use the admission of evidence of Detective Hardy's opinion during O'Day's interrogation constitutes fundamental error, which amounts to a denial of due process. His opinion did not permeate or saturate the trial with basic invalidity. The state never suggested or implied that Detective Hardy was an expert on the law. The state did not allude to his opinion regarding self-defense in its opening statement. The only reference to Detective Hardy's opinion regarding self-defense in the state's closing argument was the following. And as Detective Hardy told you, even if he threatened to get a gun and had left the store, the threat is gone. Still not legal, not legal. However, the state could have made precisely the same argument if the jury had never heard Detective Hardy's opinion. So again, injecting what Detective Hardy said, if you take it back out, does the jury come to a different conclusion? The state could have said the same thing without referencing Detective Hardy, right? So I think it's going to be the same with Sarah. If you leave it in versus take out what they said about it being her fault, is there not other compelling evidence that would lead you, if the jury gets there, lead you to find her guilty? However, the state could have more precisely... Oh, I said that. After reviewing the entire record of the trial, we cannot say the guilty verdict could not have been obtained without Detective Hardy's opinion on self-defense. That's a whole lot of negatives in there. But basically, the guilty verdict would have happened even if Detective Hardy's opinion about self-defense was not admitted. So it is not enough for reversal, right? Because if you win an appeal, it only means you get a new trial. And so they're saying even if there was a new trial and that was subtracted from it, it is still likely based on the evidence that the jury would come to the same finding. Having determined the error of admitting evidence of Detective Hardy's opinion was not fundamental error, a contemporaneous objection was required to preserve the issue for appeal. Because the error was not properly preserved, we affirm as to that ground. So in the moment, that's the contemporaneous part, the defense did not say, objection, his opinion should not be admitted, or whatever the legal objection would be, right? Inadmissible, whatever. They did it later. You don't get to the Monday morning quarterback the verdict. So in that case, so this person did not win their appeal, so I was wrong at the top when I was saying the reason he's citing it is because that person won. But clearly, the appellate court said it was an error of admitting, but was not a fundamental error. So I think that Judge Kranick is going to allow that part in. And basically, this officer was making an opinion about whether it was self-defense or not, and that it seems this person shot someone. So now we'll go into the details. So if that's all you came for, thank you for stopping by. We'll see you later. I'll just go into the circumstances of the case so we have a little more background, and then we'll get to their legal analysis. There are 3 things that were argued in this appeal. I'm only going to talk about the admissibility of what Detective Hardy said because the other ones don't apply to us. So just so we have more background on the case for those of us who are extra nosy. O'Day worked as a clerk in a Star 7 convenience store in Lauderhill with Ronnie Ashgar. The store was located in a high-crime neighborhood, and Ashgar kept a gun in the store. Christopher Morgan entered the store to buy cigarettes. Morgan did not own or have a gun. Morgan, O'Day, and Ashgar, now we're missing an H, I think it's Ashgar, gave the jury conflicting versions of the events occurring after Morgan entered the store. Morgan's version of the incident, Morgan testified that he asked O'Day for a pack of Newport cigarettes and gave him a $5 bill. What year was this that they were $5? Oh my God. Anyway, focus. But O'Day did not give him the cigarettes. When Morgan asked why he was not being served, O'Day gave him a tree wrap, a tobacco leaf used for rolling tobacco into a cigarette. So not a pack of Newports. Morgan told O'Day he did not want a wrap. He wanted cigarettes. O'Day took the wrap back, but he did not return Morgan's money and began serving another customer. Morgan told O'Day that if he would not serve him, then he should return his money and he would go elsewhere. O'Day threw Morgan's money back at him. Morgan cursed and took his money. O'Day then told Morgan that he should get the fuck out of the store. O'Day and Morgan continued cursing at each other. O'Day threw a candy bar in Morgan's face. Okay, this is the opposite of customer service, of good customer service. And Morgan then took a box from the counter and threw it at O'Day, hitting him in the front of his body. The two of them continued to pick things up from each side of the counter and throw them at each other. Ashgar told them to stop. Morgan then thought that O'Day was reaching for a weapon under the counter, so he turned around and walked to the door to leave. When he reached the door, Morgan did not turn back or say anything to O'Day, but went outside to the parking lot. Emphasizing that he did not own a gun, Morgan told the jury he did not tell O'Day that he was going to get a gun to shoot him. You can't go get something you don't have. Morgan testified that he walked straight to his car and did not look back. Consequently, he did not see O'Day walk out of the store behind him. When he reached his car, Morgan lifted his shirt to get his keys out of his pocket. He heard only one shot, felt something, and fell to the ground. Wow. Morgan further testified that he remained conscious after falling to the ground. He saw O'Day standing in front of the store holding a gun. Thinking that O'Day was going to shoot him again, Morgan pulled himself by using his arms to the front of the car. Morgan screamed to the next door barber who had come outside to call the police. Morgan saw Ashgar come outside and take O'Day inside the store. Morgan reached into his pocket and got his cell phone to call his girlfriend, who did not answer. So he left a voicemail. Morgan, why you didn't call 911? Morgan testified that no one came over to assist him while he was lying on the ground. Hang on one second. O'Day and Ashgar's version of the incident. O'Day and Ashgar testified that Morgan did not ask for cigarettes, but asked instead for a wrap or cigar rolling paper for tobacco. Following the dispute over Morgan's attempted purchase, they testified that Morgan threw store items at O'Day and tried to attack him. They don't have video surveillance up in this place? Is that what's going on? I have to imagine they have a tape. But either way, I'm just gonna... Why wouldn't he give him his money back? Let's just say all this is true. He did ask for a wrap. When he said he wasn't asking for a wrap, why didn't he run him his money back or get him the cigarettes that he would, you know what I mean? Like, that is not a reason that a gun should have been involved. It doesn't seem like Morgan was breaking any laws by asking and providing cash for cigarettes. So they're saying that Morgan started the throwing of the items, which is possible. Maybe he was just trying to get his money back. O'Day retaliated and threw items back at Morgan, who was asked to leave the store. He refused. That is when you call the police. This person is trespassing. O'Day and Ashgar testified that Morgan continued throwing objects from the counter and attempting to attack O'Day while O'Day was behind the counter. Ashgar, a large man, intervened and pushed Morgan away from O'Day. Thereafter, Morgan pointed at O'Day and said, "I'm going to effing kill you. I am going to effing kill you." O'Day further testified that as Morgan left the store, he turned around and told O'Day, "I'm going to go to my car and get my effing gun and blow your effing head off. I'm going to go to my car and blow your effing head off." O'Day testified that Morgan additionally threatened to kill Ashgar. "I'm going to get my gun and blow your effing head off and everybody working in the store." Ashgar corroborated that Morgan threatened to harm O'Day and that he challenged O'Day to fight outside. Ashgar also testified that Morgan said he was going to bring a bullet, which is slang for shooting someone. Is it? Ashgar did not hear Morgan threaten to get a gun from his car. After threatening to shoot and kill O'Day and Ashgar, Morgan left the store. Ashgar did not hear Morgan threaten to get a gun from his car. After threatening to shoot and kill O'Day and Ashgar, Morgan left the store and walked toward his car. Fearing that he was going to be killed, O'Day pressed the silent alarm button to summon the police. O'Day then grabbed the gun kept in the store and ran to the entrance. Ashgar tried to stop him, but he could not. O'Day held the store door open with his leg and remained at the threshold as he watched Morgan approach his car. O'Day testified that he watched Morgan because he was afraid that Morgan was going to kill Ashgar and him. This is my 2 cents. Why not run to the front door, you can have the gun, lock that door, having the gun by your side in case there's some foolishness outside, and then retreat back to safety where the person who's locked outside can't get to you. You've already summoned the police. As O'Day stood at the threshold of the store, Morgan turned toward O'Day, lifted his untucked shirt, and reached into his waistband. He testified that he believed that Morgan was reaching for a weapon, which caused him to fire the gun he held twice. Fire the gun twice, so he was holding. One of the bullets struck Morgan and paralyzed him. Oh no, like paralyzed him in the moment, or he's forever paralyzed. O'Day's interrogation. Detective Brian Hardy, the lead detective handling the case, conducted an interrogation of O'Day at the Lauderhill Police Department. My childhood best friend lives in Lauderhill. O'Day gave a videotape statement to Detective Hardy, which was shown to the jury. Before voir dire, the state moved in limine to exclude the portion of the video that showed O'Day crying. Defense counsel did not seek to redact, edit, or exclude any portion of the videotaped interrogation. Now, I wonder why O'Day was crying if he's the one who pulled the trigger. Detective Hardy questioned O'Day regarding what occurred at the store. O'Day admitted that he shot Morgan. He told Detective Hardy of the verbal exchanges, the throwing of items, and stated that Morgan threatened to kill him and get a gun from his car. He further stated that he shot Morgan because he was afraid of being shot when Morgan lifted his shirt, put his hand in his waistband, and turned toward O'Day. During the interrogation, Detective Hardy repeatedly told O'Day that his conduct was unlawful and did not constitute self-defense because Morgan had left the store. Of particular concern are the following statements on the videotape shown to the jury without objection, emphasis added. Defense could have filed a motion in limine like Sarah's team is doing to not have that in. That would have bolstered their appeal or their request for an appeal. Detective Hardy, I understand there was a commotion inside the store. I understand that Morgan, messed up the store. I understand that there was a little bit of a fight inside the store. Okay, he is leaving, okay? He is gone. That doesn't give you the right to turn around and shoot him. Detective Hardy, I could understand Abdel if he stayed inside the store and he starts walking up with a gun and you see him with a gun. You have every right to defend yourself, no question. I understand that part, but you didn't do that. You followed him out of the store, especially if someone is leaving, okay? We're not allowed to fire our weapons if someone is leaving. If the threat is gone, we can't do that. That is against the law. Okay, all right, Abdel. It is against the law to shoot someone, especially who is unarmed, who is leaving, okay? I understand there was a problem. That is our job. That is our job to get there. It is our job to find out what is going on, okay? If it's just a commotion, it is our job at your request to have them trespassed, okay? Or he would go to jail for the battery that he did to you by throwing that at you. But that still doesn't give you the right. And then more Detective Hardy. I understand that, Abdel, and I understand that about you. However, this is something that was outside the norm, okay? But you understand that this is against the law, what you did. Okay, that is where we are here. That is why we are here, okay? If someone is threatening you with a weapon, yes, you have the right to defend yourself. Or if someone is kicking the ever-living crap out of you and that's the only way you could defend yourself, okay, that's justified. And we understand that. And the evidence would show that. But that's not the case here tonight. Because defense counsel did not object or seek to redact any portion of the videotape statement, the jury heard Detective Hardy repeatedly state that O'Day did not legally act in self-defense. Following the showing of O'Day's videotape statement, Detective Hardy was cross-examined by defense counsel, who discussed O'Day's statement that had been shown to the jury. The cross-examination resulted in Detective Hardy again telling the story that O'Day's conduct did not factually or legally constitute self-defense because his fear was unjustified since Morgan had left the store. In addition, defense counsel's cross-examination elicited testimony from Detective Hardy that he would have acted differently and that O'Day acted unlawfully. So he elicited that testimony. He opened that door. He invited him in, and Detective Hardy said, okay, I'm coming through. Jury instruction on justifiable use. I'm not going to go through that because that doesn't apply to the Sarah case. So, but defense counsel and prosecutor agreed to the judge's jury instructions. Trial counsel, so legal analysis. Trial counsel did not object to Detective Hardy's opinion statement regarding O'Day's claim of self-defense. Trial counsel consented to the jury instructions on the justifiable use of deadly force. Consequently, neither ground asserted for reversal on appeal was preserved by a contemporaneous objection, right? You don't get to decide after you get the guilty verdict that you want to object. He had to object in real time while it was happening right before his eyes. Only when error is fundamental can the error be raised on appeal in the absence of contemporaneous objection, JBV state, which is why lawyers, you'll hear them say, I want to preserve this for the record. And I think also why Judge Kranick lets Owens shush him so that he can have that on the record, right? You want to preserve it for the record because then the appeal court will consider that. Was an objection made contemporaneously, or are you thinking about it with morning after regret? Thus, we review both grounds to determine if there is error, and if there is error, whether the error was fundamental error. Okay, so we went over that. They said it was an error, but it was not fundamental. It was not consequential. If that part had been removed, they're saying the verdict would have been the same. So we'll see. I'm looking excited to Mr. J's. I'm looking forward to Mr. J's response to this because I know it's going to be spicy and he's going to come through with probably some more relevant case law because what Owens provided is not giving. And actually, he didn't even argue, or did he give case law about Sarah's utterance? It wasn't an excited utterance. She was being shady AF. But let me just see really fast what case law he provided on the Eli and Kim situation. Okay, improper character evidence. Lack of relevance, yeah, except it does go to her character. So I'm just going to really quickly look at case law for this. What was that? What did I say it was? Oh my God. Section 9404. Okay, 404 2B says dealing with the admissibility, but it doesn't McLean v. State. I don't know if he's citing 2B though, but we'll just say dealing with the admissibility of evidence of a defendant's commission of prior crimes, wrongs, or acts of child M comports with the requirements of due process of law when used as a conduit for evidence that corroborates the victim's testimony that the crime occurred rather than to prove the identity of the alleged perpetrator. I don't feel like that one is it. And he just says 404, so we need the top level of that one. I wonder if I can just get 404. Now they're doing 404 2C. The state sought to introduce evidence of a separate incident that occurred in October. After an evidentiary hearing, the circuit court ruled that the testimony was admissible. That we're going to need a lawyer for, because is that considered testimony? I guess it's her statement, right? Her sworn statement, but is it considered testimony? And it's not anything related to the actual crime. So I would say on relevance grounds, it might be redacted, but it doesn't seem like for the character part of it, unless they're saying it's Sarah's character, but she by her own mouth. You know what I mean? Everything is by her own mouth. If only, as Kathy from Gossip Rumor Innuendo would say, she needs some shut up classes. And if you guys haven't checked out Kathy, Gossip Rumor and Innuendo, she does daily videos on true crime. She's about to hit 10,000. So if you haven't subscribed, just trickle over there and let your little finger point hit that subscribe button. You'll enjoy it, I promise. But yeah, she needs some shut up classes because her mouth gets her into so much trouble, just like her taking a stand for this, trying to get it suppressed, is going to come back to bite her. All right, that's all I have to say, y'all. Thank you for hanging out with me and the Sugar Bear and Liberty and Justice. You want to say bye? Bye. They can't see you. No, you want to say bye? How old are you? How old are you? 1. Yes, you are. Uh-huh. For now. 1 for now. Okay. Toodles.